Hi, good morning. Welcome to our webinar this morning, Independent Contractors, the Stakes Are Getting Higher. We do want to be respectful of your time this morning and, get finished as close to on time as possible. So we are going to start promptly. Additionally, due to the size of the webinar today, all of the attendees have been muted. If you have questions this morning, you'll see a box in the GoToWebinar panel on the right for your questions. So if you can type them in there, we will take questions time permitting at the end. If we do not have time to get to your question, someone will get back to you with additional information. Our speakers this morning are Paul Finkle, Certified Management Consultant and Senior Professional in Human Resources. Paul is the President of SharedHR. And Daniel Blake, Esquire, who's an attorney with LeClairRyan in Massachusetts. So I am going to go ahead and turn it over to, I believe, Dan to start the presentation this morning.
Well, it's good afternoon from Boston. My name is Dan Blake, and I'm at the national firm of LeClairRyan, and we are a general practice firm, but we have a fair number of employment attorneys who specialize in not only employment litigation, but also, to me, the more fun part of counseling and training, and hopefully avoiding problems in the workplace. So happy to be with you today.
Great. This is Paul Finkle on the West Coast. Our firm I will introduce in a moment, but first I'd like to show you how we plan to approach this topic today. We're going to go through an introduction of each of our firms in a bit more detail. Then we're going to talk about contractors and the crosshairs, which essentially deals with why we believe independent contractor relationships are being targeted by state and federal agencies. Then Dan will take us through some of the legal considerations as well as new developments in the law pertaining to independent contractors.
Excuse me, Paul, sorry to interrupt. I am getting feedback that folks are having a hard time hearing. I hate to say, if you're not able to hear me, raise your hand, but let's see.
Folks are not able to hear. I wonder if I can turn up the audio in any way here. Well, I can turn it up on my computer and see if that helps. I'll also try to speak up.
Okay. Okay, yes, I'm getting feedback that now we're getting over this technical hurdle.
Okay, good.
All right, thank you.
Thank you. So we're now looking at practical considerations, where I will take you through some of the practical considerations of challenges with independent contractor relationships and how to set them up correctly. And then we'll take questions at the end. Please understand that this topic could easily be a day seminar. In addition, Dan and I are tag teaming on this because we have an audience of national viewers in many states. So we will be contrasting and talking about both the federal standards as well as some state-specific standards. Next, let me just introduce our firm briefly. SharedHR is an HR consulting and technology firm, for those of you that are not familiar with our firm. Our business model is to share best practices and processes from over 30 years of HR consulting. Cloud computing provides us a way to translate the HR data overload into usable actions and multi-state compliance for clients on our platform simultaneously. Today's webinar is part of our continuing effort to make sense of the employment-related legislation, regulatory, and legal changes. It's our goal to give employers a window into some trends that we see and some direction on how to attract, develop, and retain the best talent while avoiding employment litigation. Dan, you want to introduce the firm?
Sure. Yeah, I talked briefly about LeClairRyan, a national firm with an employment practice, and I am based in Boston. But as Paul mentioned, we represent clients throughout the country and deal with these issues all across the nation.
Great. Next, let's talk briefly about the type of workers we're going to be talking about today. Dan, do you want to start this discussion?
Sure. Obviously, the most obvious type of worker is an employee.
Excuse me, Dan, would you mind speaking just a little more loudly, please?
Sure, no problem. Is that better?
I think so, yes.
Okay, good. First, we're talking about employees, the most obvious type of worker, and sometimes referred to as W-2 employees for those with a tax bent. And that's the kind of the standard, and there's a lot of other variations now of workers, and those are the ones we're really going to focus on today in our talk. There's a second category of what's sometimes referred to as contingent workers, more commonly called temporary employees, or in some instances a leased employee. A temporary employee is typically hired through a temporary employment agency and may work for a day or for a longer term. A leased employee, by contrast, although also not the employee of the entity that's using the services, is hired by an organization sometimes called a professional employer organization, or PEO, with the intention that the leased employee is the employee of the PEO and is merely leased to the client entity. So that's a permutation that's come up in the last 10 or 12 years, and it's being used with more frequency. The third category is on-call workers, sometimes called per diems, people that are on call to come in usually for a very short amount of time, day laborers.
Dan, if I could jump in here a moment. Sure. We term these in our practice direct hire temps. In other words, they're actually going to go on the payroll of the employer, but they're a temporary category, typically don't get benefits, and work on almost a project-type basis, if you will.
Right. And then there are independent contractors, which, as we'll talk about in a minute, are coming under increasing scrutiny on both the federal and state levels. And those sometimes can be called subcontractors, or the catch-all phrase that's used, consultant.
Okay. The next category we've termed contractors in the crosshairs. And the reason we believe that they're in the crosshairs is that we've got some anecdotal evidence here that they're being targeted both on the federal and state level. There was a New York Times article earlier in the year where the Obama administration estimated there were $7 billion in additional taxes that could be collected. This is at the federal level over the next 10 years from workers that were, quote, misclassified as independent contractors. In November of 2007, the California Supreme Court affirmed a finding that FedEx drivers, and these are kind of the green vehicle FedEx drivers, the local drivers, were actually employees under the California Labor Code. Now, I think there's some 19 jurisdictions in which FedEx is fighting these independent contractors, but they're losing in every jurisdiction. And the reason was there was too much control over what the routes of those drivers and what they were doing every day. And these are the local guys as opposed to the ones who drove interstate. And then many organizations, at least in our experience, and I think Dan shares the same experience, have become lax or fail to understand and follow proper distinctions that would be necessary to defend against an audit. So we see sort of a coming storm where both federal and state agencies are turning up the heat on these kinds of relationships, and employers have sort of not focused, if you will, or engaging entities, is more precisely, have not focused on the distinctions between employed workers and those under contract. And that was the basis for our setting up this webinar today.